So I think we can probably get started.
Should we leave?
Can you all hear me without the microphone? My name is Lori Schechtel. I'm a 1999 graduate of the University of Maryland Law School, and I currently work for the San Francisco Public Utilities Commission in the Natural Resources Division on watershed protection issues. And I'm here to moderate the panel. I think each person is going to speak for about 20 minutes or so, and then we'll take questions at the end. So if you can hold them down or write down your thoughts, that would be great. This is the legal and ecological challenges to protecting and restoring biological diversity. Our first speaker today is Anne Giquet. Is it pronounced correctly? Anne is a lecturer in the Department of Public International Law at the University of Ghent. In 2001, she received her doctorate in law and has focused her research on international, European, and national biodiversity law and policy.
Okay, thank you. So good afternoon, everybody. So my microphone is on? Yeah? Okay. So I'm going to give a talk about ecological restoration. What I would like to do is first give you a bit of an overview of policy and legal obligations for ecological restoration. And then I actually talk about what I call where, what, and how of ecological restoration. Now I'll mainly focus on legislation in the European Union, and I'll try to sort of combine legal and scientific challenges. Now before I do all that, I first want to pay attention to the benefits of ecological restoration, just by referring to a couple of international documents. The first one is a conference that was held by the Society for Ecological Restoration in 2008, which the conclusions of the conference were that ecological restoration pays, investing in conservation and restoration pays. I can also refer, of course, to the well-known TEEP study, the Economics of Ecosystems and Biodiversity, saying that restoration of natural capital can provide very high returns on investment. Another example is a Ramsar briefing note, which is about the benefits of wetland restoration. In that briefing note, they give several examples of the benefits of restoration, but they also state in this briefing note that restoring wetlands is not a justification of degrading existing wetlands. I thought that was also an important message of this briefing note. Okay, what about policy? We've had, on the international level, we have the IG targets, which were set in Nagoya, the framework of the CBD, Convention on Biodiversity, for the period 2011-2020. One of those targets, target 15, includes a target to have, by 2020, 15% restoration of degraded ecosystems, or at least 15%. Now this target is also coupled with, amongst others, to help for climate change adaptation and mitigation. At European level, this international target was also taken on in the European Biodiversity Strategy, and also there it's 15% restoration by 2020, at least 15%. At least 15%, and one of the actions in this target is that by 2014, member states, with the assistance of the European Commission, have to develop a strategic framework to set priorities for ecosystem restoration, both at subnational, national, and EU level. I can maybe add to this that there have been a recent resolution by the European Parliament of April of this year, 2012, which says that actually the Parliament actually wishes that the EU would go for a considerably higher target of ecological restoration than the 15% that is mentioned in the strategy. And they also ask the Commission to give a clear definition of what is actually meant by a degraded ecosystem. Okay, when we look at legal obligations, again, at the international level, I think it's quite clear the CBD contains provisions on restoration. The in situ conservation talks explicitly about restoration. The ex situ provision of Article 9 also contains recovery, rehabilitation of threatened species. A couple of other articles also refer to restoration. Also in the European Union, legislation explicitly refers to restoration. If we look at the corner piece of EU nature conservation legislation, that's the Habitats Directive, in the definition of conservation, it clearly refers to restoration. Now in the EU, the overall goal of the nature policy is to reach a favorable conservation status of species and habitats within the European Union. Now, when we actually look at scientific reports, we see that for most species and habitats, the situation is not very good in Europe. Most of them, the majority, is in an unfavorable conservation status, and only 17% of species and habitats are in a favorable conservation status. And when you look at key ecosystems, only 11% in EU is in a favorable conservation status. Which actually means that if you want to obtain this favorable conservation status for all the rest, you will need to restore nature. So actually, this is my point, ecological restoration is clearly an obligation in EU legislation if you want to reach the ultimate goal of this legislation. Then it comes to the point, of course, where, what, and how, because there are still quite of questions. And we have the targets now, 15%, but how are we going to do this? When I've been checking a couple of international documents, for instance, this document by UNEP of 2010, which is about restoration. Now it gives a couple of interesting things. It gives a couple of examples of restoration projects. It includes information on the benefits of ecological restoration. It gives us some recommendations and so on, lessons learned. But when it comes to legal information, not so much on legal issues. Another document is a technical report by the CBD in framework of the CBD. Also here you see lots of examples, different countries of restoration projects, but also here not really information on legal obligations or legal guidance. Maybe a little bit more in detail is this document by, again, the Society for Ecological Restoration, which contains a whole set of guiding principles for ecological restoration. And when you look at these guiding principles, there are about 51 of them, also there you see that it's mostly aimed at scientific guidance, management guidance, and they only contain very few sentences on legal aspect, and then it's rather about the constraints, about legal constraints, that if you conduct restoration projects, then you need to require all the necessary permits and so on. But guidance on where is restoration obliged, where, which species, which ecosystems, that you don't really find in this document. So still, we remain with a lot of questions. So I'll go over them one by one. The first one is, where do we have to restore nature? Well, are we going to limit restoration to protected areas? Do it only inside protected areas, or do we also need to restore nature outside of protected areas? I'll have a look at some of the obligations in the European legislation. We have in our European legislation legal ground for establishing a European network of protected areas, the so-called Natura 2000 network. Well, if we look at this obligation, the member states have already designated sites. Now they have to take conservation, restoration measures. Of course, if there is a site which is protected under this network and it's completely degraded, then it's quite obvious they will have to restore it. However, what about a site that is only partly degraded? What then? Well, I'll try to show you with a drawing. You have a Natura 2000 site, which can even include a village, a couple of houses and so on. It's usually quite a big site, which contains a couple of habitats. Now, if you look at the overall status, the situation is favorable in this example. And a couple of habitats in this, subhabitats in this site are also favorable. But there is one which is in an unfavorable conservation status. And then the question is, okay, do we need to restore this because the overall situation is good? Probably a lot of people would say, okay, you don't have to do anything there because the overall situation is good, so we can leave this. So don't do anything, no restoration in that area. I'm a bit of a different opinion because I think that when you look at obligations in the EU legislation, they say, well, okay, there is no deterioration of a sub-site is allowed, not even when the conservation status is favorable for the whole site. And also I think, and then it's where the scientific knowledge comes in, is that if you don't take restoration measures in this one site, and in a lot of areas in Europe we have quite small areas, then most likely it will lead to the further decrease of population sizes and of meta-population functioning. And in this sense, you will need to restore this one part also in order to maintain the favorable conservation of the rest of the site. Another question is, okay, now we know about restoration within sites, so what about outside protected areas? Also here I look at the example of European legislation. We have several sites in which you have to take conservation restoration measures, but then what outside? You have landscape elements, you have villages, you have houses, you have roads, all sorts of things. Do you have to take restoration measures there? Well, I think actually there are three possibilities. If it's necessary to reach a favorable conservation status, I think you either have to designate new areas, or you have to take connectivity measures to connect, it's an ecological network, to connect the different core sites. And of course also you will have to take species measures which apply horizontally. Next to those three obligations or possibilities, I think there is also in the EU law some obligations to prevent deterioration outside those protected sites, and because you have sort of an external effect of activities outside the area but with an impact on the site, and also there you have to prevent deterioration. So I think we have quite some possibilities in EU law. Of course, we also have several countries in the EU. What about a site which is protected alongside the border of two EU countries? Well, there's restoration needed, but then you look at your neighbor, so, well, they're doing quite a good job. It's okay, it's sufficient. Then, okay, the total site will be in a favorable conservation status. So neighbor has been doing his job well, so we don't have to do anything. Again, there I'm of a different opinion, and I think that each member state has to contribute to Natura 2000 and its conservation, and anyway, it's a sovereign obligation to take those measures, so I don't think you can just rely on your neighbor to do the job. Okay, second question is then for which species and ecosystems do we have to take conservation measures? Well, let's just see what the law tells us about it. I think at the international level we don't have a lot of guidance. There is not so much specific guidance on which species, which ecosystems that we have to restore. As far as I can see it, and when I read the documents, also in the framework of the IG targets, it's kind of linked to climate change, so the focus will mainly be on forest restoration, if you look at also at initiatives as REDD+ and so on. So mainly focused on forests linked to climate change. At EU level, I think we have quite a clear view on for which species and habitats we have to take restoration measures. Actually, it's those habitats and those species which are mentioned in the annexes to the directives. And also for the birds, we have a specific directive. So this is quite clear. Now for the specific sites in all the different countries, every member state has to make a list of which habitat types, which species are present there. And for those habitats and species, they have to make conservation restoration measures. Now what's important here also in the light of changing circumstances, natural or climate-induced changed circumstances, is that they have to update this information. So suppose that new species arrive because of changed natural circumstances, then they will also have to take conservation restoration measures for those species because it's a continuous process, it's not a one-time job. Okay, suppose you had species which occurred in a certain area a couple of years ago, and now it's gone locally extinct. It's not completely extinct, but locally it's gone extinct. Then what? Do you have to make sure that you restore the conditions to make or to enable those species to return or not? It's actually also a question about what reference data are we talking about, and also here I don't really find clear guidance at the international level. But for the European level, it's quite clear. You had to take your conservation measures once the directives entered into force, and it's a little bit different for birds and then for other species and habitats. But from that point of time, you have to look which species were present there, and actually you have to take measures also for possible return of those species which got locally extinct. Actually, talking about reference situations and historical reference situations brings me to the last part, which is actually how do you have to take restoration measures? What do you have to restore? To what point do you have to restore it back to? And then, of course, we are talking about reference situations, we are talking about quality standards and things like that. It's not really a big problem if you clearly know what situation it was before, if you know that you can take some normal restoration measures and restore it back to that point in time. But what if you come to a situation that because of climate change, because of intensive land use, the historical situation have changed quite dramatically, and that maybe it's even not possible to restore the previous situation back, even with taking measures. More and more, also, you read scientific articles, people saying that, okay, we will face these situations more and more because of climate change and so on. And it might become more difficult to restore actually to the previous situation, leading to lots of frustrations because you will maybe put time and effort and money in it without any of the obtained goals that you set forward. So we see that more and more scientists are also thinking about this, and they come up with some new concepts, trying to deal with these quite fundamental changes such as climate change. Now for me, it's okay to have scientific ideas, but for me the question then is, okay, how will we react to it from a legal point of view, and is maybe nature conservation law maybe compatible with those concepts? And I'll just focus on two of those ideas. And the first one is what they call novel ecosystems. There's quite a lot of attention paid to this concept of novel ecosystems last time. Now, what is a novel ecosystem? It's actually an ecosystem that differs in composition, in species composition, and or function from present and past systems. And it is also an ecosystem in which actually it's very difficult or even impossible to return to a previous state. So these are novel ecosystems, and more, a couple of scientists are really trying to promote this, not to restore to sort of historical reference situation, because that's impossible, rather to restore to novel ecosystems. Some scientists even go further, and they don't even talk about ecological restoration anymore. No, they talk about ecological design. Ecological design, really talking about completely new, sort of even synthetic systems that you are sort of consciously making up in order to reach certain goals, which can be ecological, but even economical goals. I think, right, it's probably contains some good ideas, but also contains a little bit of danger, in the sense that those kind of ideas which actually call for more flexibility and so on might be a little bit abused, or might be seen by some people. Well, if you can so easily design ecosystems, then, well, when we destroy an ecosystem somewhere because of human activities, well, it's quite easy to quickly fix some ecosystem somewhere else, and we'll create an ecosystem somewhere else, and the problem is fixed. The question is then, of course, what about biodiversity? Will you still have the same level of biodiversity? Will you have the same quality that natural ecosystems are providing you? I kind of doubt it. Another idea that you now find also in scientific literature is even more related to species, is the translocation of species. Translocation, what we call assisted translocation, or managed relocation of species. And just to give you one example, this was an article in Nature, bring elephants to Australia. So far, well, except maybe for zoos, but Australia, no, we don't have elephants. What was the whole idea behind it in this article is actually that well, Australia has quite its problems with invasive species, and the control programs do not work very well. So the author there says, well, we really should work with complete food webs. And the advantage of elephants is that they eat a certain grass, kamba grass, which is an African grass, which actually causes a lot of fires in Australia. So by introducing elephants, you would have sort of better food web, and then in this way also prevent those fires. It seems like a nice idea. I don't know what the effect would be. A little bit like this. But then again, of course, it might involve risks. I think Australia is probably the best country to know what bringing in other species, non-indigenous species, might result into. So there are risks involved. And also, of course, legal barriers. I mean, most countries do have legislation which makes it very difficult or even impossible to consciously introduce non-native species. So that might be a problem as well. Some other ideas as well. Some people are advocating that we should actually translocate species which are quite threatened. This is the example of the Iberian lynx, which is endangered in Spain, and one author in an article proposes to move them to the UK. And then we might prevent them from becoming extinct. Also here, it might seem all like good ideas, but still I'm a bit worried about all of these ideas. So that's also my conclusion. We have this target now to restore ecosystems, to restore species with concrete targets. But I think there are quite a lot of questions that we made on where will we do this, how will we do this, for which ecosystems, for which species. Because of the effect of climate change, I think people are sort of more tending to get what I call sometimes wild ideas. The sky is the limit. Everything is going to change, so why stick to these cautiously drafted targets for ecological restoration? Just go ahead and think about all the most crazy ideas. They might conflict with existing nature conservation legislation, but the biggest concern for me is, because of course a law you can change, but the biggest concern for me is that the danger for abuse. And when those people talk about, from a scientific point of view, we need more flexibility because nature is flexible, I'm sometimes afraid that it will be abused by people for mistaking this, or consciously mistake this not for flexibility but for weakening the purposes of nature conservation law. And I think there is the biggest challenge, that scientists, I must be careful what I say now, but the scientists don't always take into account what other people might make of their new ideas. And so I think that we need a debate, not only with scientists but also with legal people involved. Thank you.
Our second presenter is Colloquium Maria Flatgau, and she is currently a PhD research fellow at the University of Oslo, where she focuses her research on the ecosystem approach. She's also completed 2 LLM degrees and focused her theses on issues related to climate change.
Thank you very much for the introduction. Might be a bit difficult to follow up this wonderful presentation of Anne with the nice pictures. I don't have those nice pictures, but I'll give it a try. The presentation is built up as follows. I will spend some words on the ecosystem approach and the concept of the ecosystem approach, and then I will argue that the approach requires 3 different dimensions of integration. The integration of legal instruments is one of the dimensions. And then I will show that legal integration or legal coherence might be not that easy to accomplish because of the fragmentation in the nature of environmental law with the discretion involved. And then finally I will argue that the fragmentation and a wide margin of appreciation may conflict with an ecosystem approach, basically because of the dependency on value judgments to be performed on different parts of the same ecosystem, and something about the road ahead. The ecosystem approach. There are quite a lot of different interpretations and understandings of the ecosystem approach. The one which is most often cited is the one provided by the Convention on Biological Diversity by the Conferences of the Parties in 2000, which says that the ecosystem approach is a strategy for the integrated management of land, water, and living resources that promotes conservation and sustainable use in an equitable way. This ecosystem approach has now been endorsed in legal instruments at the international level, the EU level, and also at the national level. The main objective of the approach is to ensure the maintenance of ecosystem integrity, which is maintaining structure and functioning of ecosystems, so that a healthy level of production and provisioning of ecosystem service can be ensured. And this objective is to be achieved through holistic and integrated governance. Holistic means that we base our governance on the ecological boundaries of the ecosystem, governing the ecosystem as a whole, including all the different elements of it. And integration means that we have a look at both conservation objectives and sustainable use. As I said, the ecosystem approach requires 3 dimensions of integration. The first one is the most obvious one, as you may find this explicitly in the definition of the ecosystem approach, and also in one of the Malawi principles, the conservation and sustainable use of ecosystems. This type of integration is however difficult. You may compare it with, for instance, sustainable development, to have both economic development and environmental protection. It has been argued that one of the tools to facilitate this type of integration is through the participation and cooperation of all kinds of sectors, all kinds of decision makers and stakeholders. The importance of intersectoral cooperation has often been emphasized in discussions on the ecosystem approach. The cooperation of sectors is rather difficult, and this is true because the different sectors that are involved in the governance of one particular ecosystem, they have different objectives, they have different interests, they comply with different legal instruments through the use of different decision-making tools and traditions. One important aspect that complicates intersectoral cooperation is the legal system. At present, the legal system is rather fragmented, whereby the different elements of the ecosystem are regulated by different legal instruments. And in addition, discretionary rules and principles allow for diverging interpretation, which contributes to inconsistency throughout the legal system. And this may affect attempts to intersectoral cooperation. So these 3 dimensions of integration, they are in a way interrelated. And it could be argued that holistic and integrated ecosystem governance could be facilitated by a coherent legal system. Another reason, another rationale behind the need for a coherent legal system is the fact that ecosystems are complex adaptive systems, and this means that the system in itself has different characteristics, different features than its individual elements. So therefore, ecosystems need to be considered as a whole rather than fragmented. So a coherent legal system is needed to facilitate both aspects of an ecosystem approach, both holism and integration. So what's a coherent legal system in the light of the ecosystem approach? I will go into this question first by discussing some of the main features of environmental law. Firstly, the fragmentation, and then the discretion and principles. Firstly, the fragmentation of environmental law creates challenges to the ecosystem approach. Because even though the ecosystem approach requires the ecosystem to be considered as a whole, the legal system is very fragmented, and you may find many legal instruments which have diverging relationships to the ecosystem. You may find an amount of legal instruments that aim to conserve particular species, particular habitats. There are also legal instruments that aim to regulate particular activities within that ecosystem, such as fishery, oil and gas exploitation, shipping, building. And you may find legal instruments that aim to regulate other activities with a more indirect effect on the ecosystem. So at the end, the ecosystem may be a place where various legal instruments with diverging objectives apply. And these legal instruments, they contain discretionary legal rules. Common expressions that you may find within environmental law are that decisions need to be rational, they need to be effective, they need to contribute to sustainable development to the extent possible, if environmentally justifiable, etc. One good example from the Norwegian environmental law for the Norway's Nature Diversity Act of 2009 says that the objective of that act is also to maintain ecosystem structure, functioning and productivity to the extent this is considered to be reasonable. And the the principles of environmental law, they could actually serve to overcome the problems of discretionary powers and fragmentation, provided that they would be understood consistently, that it would be applied consistently by the various authorities. And this is, however, not the case. Most principles do not aim to determine exactly the outcome of the decision-making process. Instead, they provide a sort of normative direction, and there is a variety of interpretations still possible. So what's exactly the problem? The main problem is that discretionary rules and principles, they require the weighting and balancing of diverging values. So every time a decision has to be made, the decision-making authorities within the various sectors have to weight and balance all the different values that are at stake at that time. There are basically two approaches to carry out value judgments. The first one is based on the idea that all the different values have to be expressed by monetary terms. So all the different values have to be translated into a monetary unit. This approach uses cost-benefit analysis to weight and balance all the different values. The idea that all the values need to be expressed in monetary terms has boosted the development of valuation methods to enable ecosystem values to be expressed in a monetary term. And as today, a variety of valuation methods are being applied. The other method rejects the idea that ecosystem values need to be expressed in monetary values, in monetary terms. So under this approach, the various values may be expressed by multiple criteria. So for instance, monetary terms, qualitative and quantitative indicators. To facilitate the decision-making process, these multiple criteria are integrated in some kind of multi-criteria decision analysis, which is concerned with decision-making that involves multiple criteria. And the weighting of the values consists of a ranking of preferences. Both approaches, they are used in decision-making on the environment, but both of them also subject to technical difficulties that makes them difficult and sometimes controversial. In the context of the ecosystem approach, an important concern is that the worth of the ecosystem may be conceived differently under each decision. When the value, for instance, is when the value of the ecosystem is expressed in monetary terms, its calculated value depends on a relatively high number of variables. For instance, what kind of services are we going to monetize? What kind of valuation methods are we going to apply? What kind of discount rate? Scientific knowledge on the ecosystem services. To what extent can decision-making integrate this scientific knowledge, or instead scientific uncertainty? So there are many variables in the process. And at the end, it's quite difficult to have a consistent valuation of the ecosystem. Under the other approach, multi-criteria decision analysis, there is also a risk that the worth of the ecosystem is valued differently under each decision. And this is so because of the facts of the case, because of the facts of the case may be different, and there may be different competing interests at stake. And more importantly, the preference of the stakeholders and decision makers, they're often subjective, and they're contextualized to the facts of the case and the other interests at stake. So both approaches to value judgments on the ecosystem may lead to arbitrary outcomes, where the same ecosystem may be valued differently each time a decision is being made. And this is an important aspect to consider while we're striving towards a more holistic approach to the ecosystem. In combination with the fragmentation of environmental law, this is problematic because these various value judgments, they're executed on different legal instruments and traditions on different parts of the same ecosystem. So to round off, what do we need in order to facilitate the implementation of the ecosystem approach and to ensure its main objective? As I said, a wide margin of appreciation combined with fragmentation may impede the realization of the ecosystem approach. And do we actually need such a wide margin of appreciation? In my view, this actually complicates a holistic approach due to the arbitrariness that is embedded in value judgments on different parts of the same ecosystem. So an ecosystem approach requires environmental law to firstly harmonize the legal acts that apply to the same ecosystem. Secondly, to codify the overarching objective of that legal system, such as maintaining the ecosystem integrity. And thirdly, ensure that principles and rules are interpreted and applied in accordance with this objective. And then fourthly, to decrease dependency on and arbitrariness of value judgments by creating consistent rules on the conditions for their use, the execution of value judgments, and the implication of value judgments for the outcome of the final decision. More specifically, consistency. And the different legal acts that apply to one and the same ecosystem should use similar terminology and commonly use discretionary terms and principles. They need to be understood and need to be applied consistently. The same wording should be used for the same concept. We often see a variety of definitions across legal acts that actually refer to the same idea, such as environmentally responsible, environmentally defensible, justifiable. Legal acts should be consistent in their definitions. The understanding and interpretation of these definitions and principles need to be subject to consistency, so that they have the same implications under the various legal instruments. And we need consistency requirements for the execution of value judgments. Everything surrounding value judgments is left rather open by law. And in my view, the legal system could be significantly improved if certain issues would be regulated by law. This is first of all the necessity of value judgments. When do we require such a value judgment? What conditions do need to be fulfilled? Secondly, are there certain requirements for the weighting and balancing of the diverging values? What kind of approach do we want? There are perhaps certain overriding ecological concerns which cannot be weighted off and traded off, and these could be protected by law instead of leaving it to the discretion of a decision-making process. And finally, what are the implications of a value judgment on the final decision? Are they legally binding? Is it allowed to take a contrary decision? What happens when a decision ignores a value judgment that indicates a higher value of the ecosystem? These kind of questions need to be regulated. They need to be regulated in a consistent manner, regardless of regulatory framework. Thank you very much.
And for our third and last presentation, we have Solange Teles da Silva and Fernanda Salguero, is that correct? Cordes. And Solange is a professor of environmental law at Mackenzie University and at the State University of the Amazons. And Fernanda is a master's student at Mackenzie University in Brazil as well. Oh, just finished your master's. I apologize.
I will start and Fernanda will continue. Let's go. Thank you. Okay, well, we decided to talk about today too about protected areas in Amazon regions and the challenge of environmental, social, and cultural protection. And in fact, this paper is part of a bigger research project that we are trying to identify what are the mechanisms, what are the legal instruments that we can use to protect water, forests, and biodiversity in Amazon region. And for this first paper of that Fernanda is working on, because her master was on forest code. She studied the forest code in Brazil and all the changements, in the new forest code, and she has just finished her master, and she's maybe, and I hope so, at the end of the year starting her PhD. And so this is part of her project of research dealing with transfrontier parks. And we look at these protected areas in Amazon region, and we had founded some transfrontier parks between Peru and Brazil, and also Brazil and France, French Guiana. And we keep in our mind mostly three biggest questions. One of them, if there has been, that we could talk about participation and information in the process of the establishment of these areas, I mean the creation of these parks in Brazil, in France, and in Peru. And we would like to starting to point the main social and environmental issues in these protected areas. Of course, this is not a paper like Michele has presented 2 years ago at Ghent University with a model of transboundary parks, because we do not have so much information about these transfrontier parks in South America. It's interesting because we have so much information about African transfrontier parks or transboundary parks, and not in South America. We had started by sending emails and trying to contact the administrative board to have more information, but silence. And so we starting dealing with this issue with only the papers and the books and the articles that we had found till now. And so it's a beginning of a research, and so Fernanda will present it to you.
Hi, good afternoon. So we started our research about Chandless State Park, that is in the state of Acre, Brazil, and Alto Purus Park of Peru, National Park of Peru. And the second part is about the mountains of Tumucumac National Park and the Park Amazonian of French Guiana. So in the map we can see on the left side the Guyana border with Brazil, and in the right side the state of Acre, and where is the park of Alto Purus and Chandless State Park. Yeah, and here is also another map of Chandless and Alto Purus. And the main issue that we have in this area is about the voluntary isolated Indians that live there. In Alto Purus Park, there's no traditional people living, but in Chandless there are, among these traditional people, that we can say indigenous and dwellers people, there are the isolated voluntary indigenous people that they lives in these borders and between the two parks.
It's interesting that TI is indigenous reservations, and so it's all around this area there are many indigenous reservations that you can see.
Okay, then Chandless is known as the second park in extension in the north region in Brazil, the Amazon region, and with 600,095 and 303 thousands of hectares. It was created in 2004 by state decree. So the park was created in order to protect the biodiversity once it's considered as a prioritary area. So, and also the Alto Purus Park was created in 2004 by the Peru federal government, and there's no population, as I said. And there's an extension of 2 million 610 hectares. But the great difference between the two parks and the two administrations is about the rights of the indigenous people, because in Brazil, we have the Brazilian law consider the indigenous rights, and the Constitution says that Indians shall have their social organization, customs, language, beliefs and traditions, and rights to the lands they traditionally occupy, incumbent upon the Union to demarcate them, protect and enforce all of its assets. So lands traditionally occupied by Indians are those on which they live on a permanent basis, those used for their productive activities, those indispensable to the preservation of environmental resources necessary for their well-being and for their physical and cultural reproduction according to their customs and traditions. And the lands traditionally occupied by Indians are intended for their permanent possession, being responsible for the exclusive use of the riches of the soil, rivers and lakes existing therein. And Brazil also adopted the Convention 169 from OIT. So the main difference between this is that the Peruvian Constitution of 1993 in the Article 88 declares that the state guarantees the right of ownership over land in private or communal or any other form of association. The law may define the limits of extension of the land according to the peculiarities of each zone. And in the Article 66, it declares that all the natural resources are the nation patrimony and the state is sovereign on the usage of them. So the Indians, there's no rights. And the Indians and the Peruvian Indians that live across the border is not protected by the law in Peru. Yeah, by the Constitution. Yeah. So in Peru, the state grants rights to citizens, individuals or corporations for the protection and management and exploitation of natural resources. Then the states who has the discretionary power, competence to grant the citizens and then to the indigenous people if the government want to protection and right for the exploitation of natural resources. And therefore, there's no talking about rights of consultation and information. The indigenous people in Peru don't have this right, and the government don't have this duty, to give. In Brazil, in fact, we have the indigenous people have the right to be, not the indigenous, but the traditional population have the right to be consulted. But the consultation there is a kind of weird, because the traditional people don't, despite being consulted, don't have to be, in fact, respected. So.
I will just add this Fernanda is saying in the constitutional level, because even if there is this difference in constitutional level, if we take into account in the constitutional level, it's the opposite, because in Peru we have procedures and the consultation is possible. And so it's amazing, because we have our constitution saying things, and when we go to the practice, in Brazil is different. In Peru, we do not have the constitutional level that guarantee these consultation procedures, but they have implemented a very interesting way of consultation now, prior consultation now. So.
And the second part of this research is about the mountains of Tumucumac National Park. It's the biggest park created in the Amazon region. It was created in 2002. and as a way to achieve the goal of a IUCN recommendation for the creation of protected areas. So the park has 167,000 million of hectares, and is the biggest protected area of tropical forests. It's created among 6 municipalities and 2 states. So it's among the states of Pará and Amapá, and it's in the border of Suriname and French Guiana. So about parks, the Brazilian, I should have said this before, because the park of the Chandler's Park, created by the state of Acre as a state park, is not considered as a national park, as a category 2 of the IUCN protected areas. So it's considered as a state park, as a kind of unit of conservation. The conservation units are protected areas in Brazil, and they are there are 12 different categories, and they are divided into the complete protection and the possible of the development sustainable development protection. So this is where Mountains of Timucmac National Park is. It's a big area. And the Mountains of Timucmac National Park, it was established inside the federal territory, so we do not have so many social issues there, taking into account the right of property. And there are 2 small villages inside the park along the Oyapoc River, and there are approximately 650 dweller people living there. And the main issues that we can find there is the issues for the garbage, education, health, sanitation. There are also territorial conflicts with indigenous people in Brazil and French Guiana, because these dweller people, are used to fish and hunt inside the French territory and not inside the Brazilian territory. And the Amazonian, so the Amazonian Park of French Guiana, that was created in 2007. After it was the declaration to be created for the creation of this park started, in fact, during the summit of Rio in 1992, and but it was really created in the 27th February of 2007. The Guiana Park is presented as a park for environmental protection and development, and as a way to implement and to support people in their development, because there are people living there. So the decree of the creation of the park gave to the in fact, there's the decree of the creation of the park, and it gave to the administration council that is formed by 10 state members, 12 representatives of the traditional population, 5 representatives of indigenous and bush-native populations, and 16 other personalities. So this council is the one that is competent to to regulate the park. And the park was created under a perspective of cooperation also between Brazil and France. The indigenous people in France do not have the right to recognize it as indigenous people and over the lands occupied by them. The decree gives to the Council the competence to create the letter of the Amazonian Park. There is the main regulation instrument, and that is able to establish the right and even the declaration of existence of the indigenous people inside the park. And this letter divides the park into 3 areas. Among them are the Ziduk, is that the hunting and fishing practice are forbidden, even for the indigenous. There's a zone it has an extension of 20,300 square kilometers, and there's a zone of free adhesion that is a zone for sustainable development, where the use and exploration of natural resources are decided by this council, responsible to create, of course, the letter of the park. And the zone of environmental protection, that is the heart of the park, and the zone of environmental protection has an extension of 20,300 square kilometers, and the zone Ziduk has an extension of 13.6 thousand square kilometers. So both of these zones, the ZLA zone and the Ziduk zone, the indigenous people can live. In the Ziduk zone, the indigenous people can live and explore the natural resources, even the gold. So the zones are usage right zones. I did that. The Ziduk zone is the usage right zone, and the zone of environmental protection is the heart of the park, is the biggest one, and there's no way, it's forbidden to have exploration of natural resources, and even the living of indigenous people are forbidden there. And in the zone of free adhesion, it's for the sustainable development. So it's a zone where the exploitation of natural resources is not forbidden. Both of the park were established as a cooperation way for the better administration of the environmental resources of both countries, but there's a need of improvement of this administration and for giving more efficacy for the environmental protection, even because inside the Tumuco-Maki Park and mainly inside of the Amazonian Colloquium Park, there's an amount of almost 10,000 illegal golden exploration workers, and it causes a lot of environmental damages and a lot of social and environmental issues. So that's it. Thank you very much.
So we'll have time now for questions. We actually have a bit of time because one speaker was unable to attend. I just want to say thank you to the 3 presenters. I thought they did a nice job and had definitely some coming from different perspectives. But I think there was some commonality too between all 3, and especially with the first 2, that there is a lot of difficulty that's faced in terms of knowing, I guess, where and how, the wheres and hows of the ecological restoration, without having not just a comprehensive set of legal instruments governing restoration, but more specificity in the regulations and the laws and more streamlining versus the fragmentation that you were speaking about, and also prioritizing areas for restoration, which is very different than how things are run in the U.S. Because we do a lot of restoration, at least in my job, and it's very project specific and very much on a local level. So I want to just open this up to questions and answers. We have plenty of time.
Am I loud enough if I speak like this?
Yes.
Okay. I have a question to Mevrouw Platja. A very simple question, and my question is, what is wrong with discretion? And if I'm allowed to give a tentative answer to my own question, I would say there's nothing wrong with discretion if and when we really need it. And when do we need it? I would say when it's impossible that a legislator or a regulator makes value judgments on ecosystems in general, in abstracto. And of course, if the legislator is capable to prohibit a certain way of use of an ecosystem, it should do so. But discretion is necessary, I would even say unavoidable, if we want tailor-made decisions taking into account all relevant factors and circumstances. So discretion is an unavoidable evil. And then the next question is how do we tackle the evils of discretion? And I'm not sure if I would follow your approach to harmonize, if I understood you correctly, to harmonize all legal acts, norms and standards applicable to ecosystem. You spoke about the evils of fragmentation, but then of course you would create a new set of fragmentation. Indeed, you distance ecosystem law completely with the rest of law. So what would be then my approach? Discretion is of course not a particular problem with respect to ecosystems. It's inherent to public law and administrative law in general, also outside environmental law. And if you look how the evils of discretion have been tackled in these other parts of public law, I would say there are two other principles: the principle of transparency and the principle of consistency. If you require public authorities to make fully transparent by stating all reasons available on how they came to their value judgment, then of course it is transparent and it is being made public, and is of course also available to courts and to have judicial review on that. And I would say the other principle is the principle of consistency. Of course, value judgments have to be consistent with each other. So isn't that in terms of proportionate response, a better solution to tackle the evils of discretion, discretion? Transparency, full transparency, and a full application of the consistency principle.
Do you guys want to answer the mics, or do you want to?
I think you can hear me.
Everyone here?
Yeah, a lot of questions.
Well, only one. What is wrong with discretion?
What's wrong with discretion?
Forget the rest.
I think the ecosystem approach in itself, which has been developed since the last 3 decades, it requires a holistic approach. And discretionary law, it provides a risk that we don't acquire, that we don't achieve holism, in the sense that when we have discretion in the law, those value judgments have to be made over and over and over again. And my problem is that the ecosystem has a value no matter what. And I don't understand why this value should be calculated every time a decision has to be made. I think it could be much more easy when we establish a value of the ecosystem, when we say this is the value, and then the decision maker can balance this value against his values, his interests. When we have a consistent value, and then I think discretion is fine to make trade-offs, to make a weighting and balancing assessment. But the point is that discretionary law, it requires the valuation of the ecosystem. And that's difficult, it's controversial. and almost never the real value of the ecosystem is valued at its real value. So you always have a value that's below its real value. So in one way, it avoids, or it avoids coming to a holistic approach. And in the other way, I think it makes it difficult to ensure sustainability, to ensure sustainable ecosystems when this value is taken up through discretionary processes. I think transparency in the process is a good issue, but at the end, it doesn't require any. Guaranteeing the ecosystem integrity. So in a way, I think we should reduce discretion and take more efforts to protect the value of the ecosystem. And as I said, I think we can establish the value of the ecosystem by allowing economists and scientists to come to a value they agree on, and then making decisions, whatever decisions they want. But just having a consistent value and having the discretion on the valuation process, the monetization process, what kind of valuation approach do we apply, and those kind of controversial issues out of the discretionary process.
To keep it out of the basket of weighing of interests.
Yeah, have a kind of agreement across the sectors on the value of that ecosystem.
Thank you.
Did I answer all the questions?
Yes, I guess so.
My question is for Anne. So first of all, I think that having a legal obligation for restoration in itself is a really wonderful step forward from, no harm and everything like that. But if I grasp the main content of your presentation is that they haven't really worked out clearly the definitions needed to implement this. And I'm just wondering if perhaps you could elaborate a bit more, because one of the things you said was that where an ecosystem is highly degraded, then that clearly triggers the obligation to restore it. So I was wondering it sounds like the legislation hasn't considered the effectiveness, because with ecological tipping points, if say an ecosystem is completely degraded, the amount of efforts that are needed to restore an ecosystem that's beyond that would probably be better to put the resources somewhere to an ecosystem that's not so degraded, and call it the triage approach, which they borrow from medicine, in that with ecological restoration you're probably best off to apply the funds or the effort into a not so degraded ecosystem for more bang for your buck and that sort of thing. I'm wondering if the legislation has considered those issues.
But I think not on the international level and also not on the European level. I think that they already clearly defined on where do you have to prioritize first. That's actually, first they set a target and now they start to look for answers on how to fill in this target. And actually where they only are now is at the level of gathering information. That's what, if you look at CBD documents, that's what they are doing now. Try to assemble information from all over the world of restoration practices, guidelines, national legislations, regional legislations, and so on. But you don't really find clear targets, and indeed do you have to prioritize for those ecosystems which are really degraded, or those which are mainly only partly degraded, and then maybe have a better rate of success of taking minimal, and where to put in the resources and so on. There's no clear guidance on that.
I was really intrigued by this concept of a novel ecosystem, and I'm wondering what is the legal obligation for restoration vis-a-vis a novel ecosystem? Because you have a presumably functioning ecosystem that has some sort of ecosystem services it's delivering. Is there an obligation then to try to, what is your take on that?
I think the concept of novel ecosystems is quite new, so I don't think you have any obligations on the legal level for these novel ecosystems. And also I think in detail, legislation when it comes to restoration and the goals you have to achieve is when I look at EU legislation, the ultimate goal is favorable conservation status. So whether you do this by making, by using mitigation measures, compensation measures, and creating a novel ecosystem, or restoring a partly degraded ecosystem, as long as you reach a favorable conservation status, that's where you aimed at. I don't know if this answers his question.
Can I say something about restoration? For example, the new forest code in Brazil says that mangroves, they are degraded, where there are degradation that you cannot restore. It means when we have high, where we have oil, where we have things that are very bad for the healthy, we can have land tenure. We can leave people, keep this land for the people who lives already there. So it's a opposite side of said the constitutional law in Brazil, the constitutional text, and I hope that we will have some action of constitutionality actions, because it's something very it's terrible. It's terrible. You can't imagine. We need to restore, and they said that no, well, we need no more restoration. People can live there. Poor people, of course. So
so once it's completely degraded, then
it's completely degraded. The poor can live there. Yes, that's the new forest code, new Brazilian mangrove, only for mangrove. It's that we have now. So you can imagine how it was the fight against this new forest code. How it was hard, and it's still hard, but there are a lot of things inside that are real regression of our environmental law. And you say that we are in this movement of regression of our environmental protection in Brazil.
This session, first of all, was great. And I like the title, which is why I was so interested. Because the title itself is bringing together, almost explicitly, science and law. And I so much appreciate that this was part of really all three of the presentations. I'm working with protected areas legislation. I think in your packets, there is the latest guidelines for protected areas legislation that I worked with through IUCN. And at least half of our reviewers, this was a 4-year project, at least half of the reviewers and the participants were scientists. Because what we were trying to do with those guidelines is push the envelope. Not only the problems we've had in the past and the struggles and how we can write another law journal article on the difficulties, and then with a paragraph at the end saying that this is where we want to go. The whole purpose of that was to move us forward, because we have too many challenges. We have climate change. We have 7 billion people becoming 9 billion people. We have this whole idea of ecosystem functions that the planet needs, we all need. So these are sort of really fundamental issues in law now that I hope all of us in the environmental field can begin not only to talk about in our academic world, but in our communities at large, because other people who are the ones who vote and influence the legislatures, so that when there is a discretionary decision, people are well informed. This sort of cycle, I think we have to be leaders and pioneers. And I just wanted to make one more point. From the protected areas legislation guidelines, which is a nice, clean, relatively speaking, concept using the IUCN categories from strict to multiple use to landscape. Now I'm working on this concept of connectivity conservation, which is what you were talking about with the ecological network. Brazil has the corridors that are beginning to move, and Norway, I know you're part of this broader ecological framework. And the issue there is law hasn't even begun to touch it. I mean, we're moving into a field where we have to essentially respect and become part of our colleagues working in land use, and working in marine spatial planning, and working in taxes, and giving economic incentives, and trying to convince people how to do voluntary conservation, because that's really the future, isn't it? And so I guess this is more of a comment, and please, anyone of you presenting, add your further thoughts, but I just thought these presentations are so important because they help us maybe set the stage for what we all must continue to do even more.
I want to make a little comment there. About the discretionary decisions, I have just wrote an article in Portuguese, but I think that the foundation of public decision is take into account time and space. And so when I say time, is our environment in the present and in the future, and the space where this decision is taken into account, but also take into account this connectivity. Because sometimes it's in a little municipality that the mayor, how I say that in English? The préfet? No,
The mayor.
The mayor take one decision, a public decision that can influence the other municipality or even the state when you talk about federal system like Brazil. And so I think really that we need to think that there is a space for discretionality, but not when you talk about, but taking into account this base of space and time. You know, and after you can choose, but you cannot choose if you will protect or not the environment. There's no more place if you leave this flexibility to say, oh, you can now protect this or that. And I'm a little afraid about the logic of compensation in this way, because we never know what are we compensating. For example, before Rio +20, we had the increase of one protected area in Brazil, but 4 or 5 are diminished to build the dam, you know, and so to give space for the building, the construction of the dam in the north part of Brazil. And it's maybe time to talk about other fields of the science and communicate, and trying to know how to communicate. Maybe we are failing in this point, communication with the others, to say, hello, it's time, it's now, and if not, maybe we don't know what will be our order, we can say like that.
So just a question with the dams, the building of the dams you just mentioned, there was no mitigation required to restore habitat in off-site or close by, or no requirements?
No, there are requirements, but for example, nowadays the requirements are not observed if you take into account the last dam that is building in Brazil, Belo Monte Dam. I feel that we are returning 20 years ago, you know, the fights are starting, we are starting again all the way. It seems to me like we have a great job to do with the new generation.
Well, also a question that's related to your remarks, but maybe the question is more directed to Anne. and also in view of what has been said on these novel ecosystems. In Europe, we more or less already embraced the concept of novel ecosystems, maybe not in the context of restoring, but in the context of derogation and compensation. We call it compensation. That's what we do. Sometimes we have to destroy an ecosystem, and then we compensate, and then we create a new ecosystem. Well, I'm a little bit simplistic, but my question is, could you dwell a little bit on how you see the relation between these novel ecosystem and compensatory measures?
But I think when you look at scientific articles on these novel ecosystems, it's not really. I think most of them are not written from a European perspective, and we already know the concept of half-natural ecosystems and so on, and indeed we know the concept of compensation. I think they really are more, and when we compensate, we usually compensate in areas which may be partly degraded, but we restore them to a better level of better conservation status. But these novel ecosystems, they more tend to, okay, you just create something new, which is totally not resembling past situations of species composition and so on. And I think in Europe what we mostly try to do is even when we compensate, it's even an obligation that we compensate to at least qualitatively an equal habitat. When we lose a marshland, we have to compensate for another marshland. So I think actually what we do with our compensation in Europe is still looking for historical reference situations and so on. Only with the compensation we do it in another place.
But what are we doing? Because we are neighbors. Huh? I'm from the Netherlands, and she is from Belgium. We have this. Both our governments have agreed to destroy, at least for a part, one of the most interesting wetlands in Europe. And as a matter of compensation, we flood a polder, which indeed creates a new ecosystem. At least that's what we hope. Maybe Mr. Faber can join us as well in this discussion. But I would say that is creating a novel ecosystem, or as a means of restoration. Compensation, and maybe we're not even.
I would rather say it's restoration to a previous system.
Well, then everything is restoration to a previous system. And if we take time into account, if we go back long enough, okay.
But I don't really have a problem with the concept of such a novel ecosystem. The only thing is that my worry is rather that it's going to be abused. That
I agree with you. Yeah.
That's my biggest problem. Not with the fact that they need what we know in Belgium and in Flanders and in the Netherlands and so on. I don't have a problem with that. But I sometimes see reactions in Belgium as well with the obligation of compensation, that you lose a valuable wetland, and then especially people from other departments which are not ecologists and so on, then they go like, okay, we've got a very easy fixing solution, we are engineers and we'll create another wetland somewhere else. Quality standards, biodiversity, well, that's something they put into their notes, but actually in practice,
maybe we should import an elephant to that polder. That would be not restoring.
They will probably drown.
Yes.
I'm just going to divert the conversation. I'm really curious about your research, Renata. And I was wondering if maybe you've had a chance to look at all at cases in Central America. I know it's not South America, but I think there's some really interesting transboundary collaboration happening there that has some similar traits to what you're talking about. If you look at La Amistad between Costa Rica and Panama, you have the eastern border bordered by indigenous lands as well, and then the western bordered by communities that were many moved out of the park land. And the park administration has the same sort of different legal frameworks, different levels of authority, and they're working in many of these cases with the indigenous and with the local communities, and not necessarily by mandate, but because out of necessity and because of proximity. In some cases, like in the La Amistad Park on the Costa Rican side, there's 9 park rangers for over 100,000 hectares of land. They have to work with the communities. So that's what they're doing, you know. And then they let the indigenous be the buffer zone and the administrators protecting the eastern side. And then in Honduras and Nicaragua, there's some parks there, and I noticed that in many places, you know, it's not legally required to consult the indigenous peoples, but because the indigenous they're the high population in the community, they, by default, the mayor, who is indigenous, will say you must go and consult the indigenous tribunal before we can grant you any kind of permit for it. Whatever. So these things maybe aren't in the laws, but they're happening on the ground. And I wonder if you've seen that as well in your case studies. I'm sorry to hear that.
No, there are some news that we have brought some papers and some things saying that there are this kind of cooperation on the ground. But what I was trying to see, if, for example, if there was an agreement between Brazil and Peru, nothing. Between Brazil and the French Guiana, there are more official cooperation. But what we found is more study of the park in the side of Brazil or in the park, you know, we do not find studies about this cooperation. There was only one thesis that was made in 2008 that made a little study about this collaboration, this cooperation. So because of that, it's only one thesis in Brazil. And so it's little. Because if you look at Limpopo or other parks, there are so many articles, so many things that has been done.
I'm really glad you're going to do your research.
Thank you. But my
I found that a lot of the transboundary protected areas, that cooperation between the governments is not always codified. Yeah, and but sometimes if you start talking to the people who are actually working in the parks, they know what they're cooperating on and what they don't, and they send things to each other, their management plans, their different policies and ideas. So it sometimes takes a little more thinking. Yeah.
It's very interesting to go there, to go to this plaza.
We'll try to have the resources to
Yeah.
to do that.
And then share with us.
We'll try.
Yeah.
It's the point.
Sorry, we're having some good conversations. Does anyone else have any other questions before we wrap up? We have a few more minutes, so ask away or. Think that as a no? Is that do you want to? Yeah.
Yes. I was interested in restoration because all your questions at the end you say where and don't you think that we need to maybe to think about the ecological corridors and in this way think about restoration to have this kind of corridors? This can be a guide to think about restoration or something like that.
Absolutely. I think and this is also the direction that the European Union is going to when they talk about restoration. They combine this target with their emphasis they put now on green infrastructure, and green infrastructure is actually the whole connectivity story that you have to start connecting the different protected areas and use green and blue landscape elements to connect it and so on. And I think also another part of the world, but it's like you said, the whole idea of connectivity is just from a legal point of view, we're just only beginning to start doing something, but I think this is something that really needs a lot of attention because we see in spite of all our protected areas, we don't reach for the goals that we need to reach, and so I think connectivity is a huge issue, but a very difficult one to tackle because in protected area you usually have quite some legislation, you usually have the ownership by the government and so on, but for connectivity measures you're often confronted with ownership that's not belonging to the government, other land uses, farming, forestry, whatever that interferes with this, so it will be quite a difficult challenge to do this, but I think this is really a main issue which is to focus on.
Any further questions or comments? Thank you. Thanks for coming. Thanks for coming.